Assalamualaikum warahmatullahi wabarakatuh. Welcome to our Zoom recorded lecture. So the topic for today is performance of the contract. Actually, this is the final three topics in our syllabus because after this topic, performance, the next topic will be frustration or impossibility of performance. And then the final topic will be images. Okay, now let's focus on performance of the contract. Okay, so far we have covered, especially in your part one, we have discussed thoroughly about all the elements, ingredients of a valid and possible contract. And in the earlier part of Law of Contract 2, Law 121, we discussed about vitiating factors which might affect consent of a contract. And eventually the contract might become voidable. So now the final part of a contract, the final stage basically, you want to see in what way the contract, those enforceable valid contract can be discharged. How the contracting parties can release themselves from the obligation under the contract. So basically a contract may be discharged by a number of ways or methods here. Okay, the first one, it can be done by way of performance, which is our topic. And another way of to discharge the contract is by way of agreement, meaning that here the parties agreed to enter into another agreement. Or another way a contract could be discharged is by way of breach, whenever there's a breach on the part of either party, or sometimes both parties actually committed their own breach respectively. And then the last one is frustration, which is our next topic after we have completed this topic. Okay, let's move to performance. Okay, what's the rule governing performance? Let me adjust the camera. Okay. Right. So what's the rule governing performance here? So the rule is that once the contracting parties, okay, offeror, offeree, or even we use the term like proposer, acceptor, okay. Once these parties, okay, bilateral contract, the parties agreed, okay, signed, executed the contract. So basically, the next thing is that the parties here must perform precisely all the terms, okay, whatever terms that they have agreed between them, okay, all the terms of the contract in order to discharge their obligations. So if they agreed to perform A, B, C, D, for example, so they must perform precisely all the A, B, C, D, the terms here. Okay, example, in a common, in most of the contract, it involves usually sale of goods, okay. In contract for the sale of goods, okay, the goods, which is the subject matter of the contract, must correspond, must tally with the description. For example, if Mr. is buying certain things, okay, with all the description, with all the features, okay, with all the specs, okay, so he is expected to receive those things which is described, okay, as per their contract. We have the case of Moore and Landor, 1921. This is common law classic example here. Like what happened here, they entered into agreement, okay, the parties entered into the agreement for the sale of 3,000 tins, okay, that's the number of the tins, okay, 3,000 tins of canned fruit, and it is to be packed in cases of 30 tins, meaning that here, every case it contains 30 tins, up to the total of 3,000 tins. But when delivered, okay, it was discovered that half of the cases contain only 24 tins instead of 30 tins that they have agreed earlier. Although when it was counted, okay, the total number of the tins was still 3,000, but only the difference is that it is packed in maybe smaller boxes or with fewer number, lesser number of the tins here. And then as far as the price was concerned, the market value of the tins here, the canned fruit here, was not affected. All right, and this is a decision by Court of Appeal because later they have a problem, they have the dispute, okay, they bring the matter to the court. And the observation by the Court of Appeal is that, okay, notwithstanding that there was no loss to the buyer because the price still remains, okay, the market value was not affected, he has the right, legal right, he could reject the whole consignment. It's either he accept or he reject the whole thing, okay, because why? Because of the breach of Section 13 of the Sale of Goods Act, in which it says that goods must correspond with the description. actually before it was codified, so whatever decision, they just refer to the case law. Okay, but then later the rule was codified and then was incorporated in the Sale of Goods Act here, section 13. But for us, we also have Sale of Goods Act 1957, which especially section 15. Okay, let's move. Let's have a look quickly at section 15. I think I have to stop share first. Okay. All right, and I share the screen here. All right. So this is the one. Okay, section 15, Sale of Goods Act 1957. It says that, okay, here, all right, where there is a contract for the sale of goods, okay, by description, okay. So meaning that here there is an implied condition. Remember, you discussed condition warranty in your part 1, okay, of law of contract, that the goods shall correspond with the description. And if the sale is by sample as well as by description, okay, it is not sufficient that the bulk of the goods correspond with the sample if the goods do not also correspond with the description. So it must tally with the description. So that's basically section 15. Okay, you can have a look at all the provisions later. Okay, I stop share and then we go back to the slides. Okay. All right, we were here. Okay, that's the observation of the court. Okay, and then it was incorporated into section 13 of Sale of Goods Act. That one UK English law, but for us we have section 15. Okay, another issue that could be considered or relevant to the rule just now, okay, what if the deviation is microscopic? Meaning that here, what if the things which does not tally is just so little, just a little thing, tiny things here, okay? So the answer is that if the deviation is microscopic, okay, microscopic is like microscope, okay, very small, which means extremely small, tiny. So in that particular situation, most of the time, okay, the court will consider the contract has been correctly performed. Meaning that here, there's nothing wrong with the performance of the contract. The party cannot simply reject or cannot simply set aside the contract. Okay, let's move further. We have another case, Carter and Powell. This is a landmark case, okay, which is very important because it sets the rule and the new rule later. Carter and Powell, 1795. So 18th century case here, classic case, landmark case actually. So this is a classic example of hardship caused by the rule. Hardship is the difficulty, okay, all right. So a seaman, it's like sailor, okay, a seaman who was to be paid his wages, his salary after the end of the voyage, okay, but he died just a few days away from port. So before the vessel or the ship, okay, could reach the port, so he died. So, but in the contract, he has to complete the whole voyage, then only he can get the salary. So later, his widow was not able to recover any of his wages because he had not completed performance of his contractual obligation. So what's the obligation here? He is obliged to complete the whole voyage, but he didn't manage to do it because he died before. Even though just a few days, he had been on sea maybe for months, but then just a few days to reach the port, so he died. So no single cent was to be paid to the widow. It's not entitled to the payment, right? But later, because remember the case was reported in 1795, but later the things, okay, the matter was codified, so was rectified. So this situation is now provided for by the Merchant Shipping Act 1970. I think we have a similar act here. Okay, there comes also what's the significance of Carter and Powell. So basically, Carter and Powell, it represents the law on entire contract. So, and then it has produced great injustice, difficulty, okay, unfairness here. Why? Because if the parties entered into the contract and then he is obliged to perform the whole contract, then only he is entitled to the payment. Then if he cannot perform the entire contract, then is not entitled to any single payment at all. So actually, it caused great injustice, like the one which is illustrated or what happened in Carter and Powell. Okay, so because of that, the rule has to be modified. Okay, we need to rectify or we need to we need certain ways to mitigate, right? To mitigate the harshness or the injustice here. So the strict rule as to performance is now mitigated in a number of instances. For example, we have the rule governing divisible contract. And another rule which is so important that we are going to discuss thoroughly after this is the doctrine of substantial performance. Meaning that here both of the rule here, it try to mitigate, it try to rectify the harshness which is caused, okay, in the earlier cases. Like for example in Carter and Powell that we have discussed just now. Okay, so what is all about divisible contract? Entire versus divisible. So we want to distinguish, okay, what's the difference between the two nature of type of contracts here? Okay, entire versus divisible. So divisible contract is separable. Okay, divisible means separable. It's possible to separate into parts. Part 1, part 2, part 3, for example, few parts here. And then how do we deal with it? Okay, part of the consideration is one of one party is set off. Okay, that's the keyword, set off against part of the performance of the other. Meaning that here, if the party has performed this part and then he is able to claim for that part, so we set off against part of the performance, even though it's not really complete performance yet. So example is agreement for payment pro rata, that is to pay proportionally. Meaning that here, if performance is 20%, then payment is 20%. So it's pro rata or proportionate. So what's the meaning of the word entire contract? So where the agreement provides that complete performance by one party is a condition precedent to contractual liability on the part of the other party. Meaning that here, until and unless the other party perform the contract wholly, 100%, then only payment will be due. Okay, will be made to the other party. So that's the nature of the contract. So divisible or entire contract. Okay, let's go to the proper definition of entire, or sometimes it is also called lump sum contract. A contract is said to be entire, okay, when complete performance, okay, full performance, whole performance by one party is a condition precedent to the liability of the other. I mean that here, only after the party, one party perform the contract wholly, 100%, then only liability will arise. Liability to pay will arise on the other party. In such a contract, the consideration is usually a lump sum, which is payable. Whatever payment is lump sum payment, okay, only upon complete performance by the other party. So that's why sometimes it is referred to as a lump contract or lump sum contract or lump, because why? It requires complete performance, then only lump sum payment will be made. So this is basically taken from Treaty on Contract, one of the textbooks, okay, General Principle 28th edition. Let's move further. Okay, all right. So how to know? Okay, how do we ascertain, okay, whether a contract is to be construed, to be interpreted as entire or divisible? Or sometimes another related term, similar term is severable. We can sever into parts here, right? So the question whether a particular obligation is entire or severable is actually one of construction. It depends on the parties. It depends on the court how to construe, how to interpret the terms. So when a party agrees to do work under a contract, the courts are reluctant, most of the time, okay, the courts are reluctant to construe the contract so as to require complete performance before any payment becomes due. So wherever possible, the court will try to use its discretion to construe, to observe, to hold that the contract is actually severable or divisible rather than entire. Remember, entire contract cause injustice in most of the situations, okay? And this is taken from J.H. Triton, another textbook, okay? The law of contract. Let's have a look at another case here, another landmark case, common law, Sumter and Hedges, 1898. What happened here? The plaintiff is contractor here. Okay, the plaintiff agreed to erect or to construct upon the defendant's land 2 houses and stables at the price of £565. Okay, so that's the obligation which is undertook by plaintiff here. But what happened was that he did part of the work to the value of about £333, meaning that here is more than 50%, but it's not yet completed. It's not 100% completion or performance here. And later he abandoned the contract. So because of that, the other party, the defendant, has to complete the building. So defendant eventually managed to complete the whole building. So So whether we can allow the payment to the plaintiff here, right? So the court held that plaintiff could not recover the value of the work done because why? He is at fault. He had abandoned the contract, and as a whole, the contract is entire in nature. Okay, you must complete the whole thing. Then only you can ask for the payment of the full amount, 565 £65 here. Okay, otherwise you are entitled for zero payment as far as whatever partial work was done, incompleted work. Okay, all right. So cannot claim at all. Okay, let's move further. We have a local case on this point. Okay, the case is this also a landmark. Okay, because why? The decision was made by federal court, the highest apex. Okay, of court here. So Yong Ngok Hin and United Malay Sugar Industries Limited reported in 1967. So again, the contract involved contractors here. Contracts between building contractor, who was the appellant, and it's between the respondent. The respondent was the purchaser of the office building. So contractor is supposed to complete the building, basically. Okay, all right. What happened was that purchaser, okay, respondent did not pay the fifth progress payment, and because of that, appellant then abandoned the work on the site. So here, who's at fault first? Okay, the respondent did not make the payment, fifth progress payment. So the payment was made progressively. First payment, second payment, third payment. So until fifth payment, fifth progress payment, no payment was made by the purchaser. So because of that, contractor decided to abandon the work on the site. Of course, the work is still incomplete. So, and when the case was brought up to the federal court here, federal court held that the contracts, okay, as a the court has to see what's the nature of the contract first, okay, before the court give the judgment. So federal court held that the contracts were actually lump sum or entire contract. How the court know? Okay, the court examined all the terms between the parties here, the contract between them. So based on the wordings of the agreement, okay, what's the wording? This is actual wordings from the contract between them. Advances may be made towards the contract during progress of construction at the respondent's discretion. So actually, this is not. The purchaser has the discretion whether the option to pay or not to pay, and he decided not to pay during fifth progress payment. So he's not at fault. He's not in breach, basically. So because of that, the appellant, so whatever payment he has done before is at his discretion. So appellant was not entitled to any payment for work done before completion of the work. So that's the finding by the court. So the whatever terms in the agreement is very, very crucial, very, very important, because it will give the implication later during whenever there's any problem with the performance of the contract. Okay, let's move further. Okay, all right. Okay, we have another case. All right, before we go to the case, we also have a exception to the rule here. Actually, how the court tackle or how the court resolve the problem between the parties, how the court give the judgment, okay, to resolve the dispute. So in some situation, it's possible actually to infer that there is new contract between the parties here. So this is an exception to the general rule. And it will allow the contractor to receive payment before completion of the work, because otherwise, okay, the contractor has to perform 100% okay, construction, then only he is entitled for 100% payment. So how it is done? Okay, in that situation, new contract is implied, okay, to pay remuneration, to pay whatever payment here equal to benefit derived from partial performance. We have the case here, right, to illustrate to us the rule just now. The case is Smith Construction Company Limited and Fit Kirivatna, reported in 1955 in MLJ. Again, it involves certain construction of a house, building here, house basically. Plaintiff were building a house for the defendant, so plaintiff were the contractor. And later, problem arose because why? Part of the house that they were building, encroach upon an adjoining land. They only realize it later, after the construction has started. So because of that, defendant's architect requested plaintiff, requested the contractor to slow down. Okay, and this resulted in increased cost. Obviously, the moment the work slowed down, so of course it will incur more expenses later. Right, what happened next? Okay, all right. And then the contractor, plaintiff, asked for the payment of the work already done, because defendant was the one who asked for to slow down the work. And defendant on their part here failed to issue architect certificate to value the work which has already been done by the plaintiff. So because of that, no payment has been made, so plaintiff cannot proceed with the work. So plaintiff eventually stop work and plaintiff claim breach against defendant here. And this is the judgment or observation by the judge, Spencer Wilkinson. And this is the actual quotation from the judgment here. The court said, if it was an entire contract, the plaintiff could not sue until they have completed the work. But however, as far as the case was concerned, we don't apply the general rule. Okay, exception is applied in this case. Because why? It is based on two factors here. The first one, the court look at the defendant's letter, the correspondence between them. Okay, defendant's solicitor's letter imply a contract by the defendant to pay for the work done. I mean, it's not stated in the contract, but then from the letters, as the implication is that payment will be done for whatever work done by the plaintiff here. And another factor is that the court look at the common building practice here. Because whenever the work stops, especially at the request of the defendant, so the builder will be paid up to the date of stoppage. It's not the fault by the builder to stop work. Its decision is by the defendant. So the defendant has to pay. So that's the common building practice. So there are two factors in which the court took into consideration as far as the case was concerned. So that's basically the first part of our lecture for performance. We are going to continue later in part 2, basically to discuss the rule governing substantial performance. Okay, I stop share first. Okay, all right. So I hope you can follow the lecture. Assalamualaikum warahmatullahi wabarakatuh.